Hi everyone, today we're going to be talking about the National Judiciary. So we've moved on to the final section of the three branches of government and the checks and balances system. So let's talk about federal judges. Think Supreme Court justices. Federal judges are appointed rather than elected. They serve for life rather than in terms. And the system is in place to keep them impartial, to make sure that they make decisions based on good judgment and being fair rather than wanting to win elections again. So a justice is not going to have to worry about making a decision that their electorate would want them to make rather than what has already been established as precedent before that. So when the system was originally made, states decided how legal matters were settled. But the major problem with having states decide rather than the whole country is that every state's going to decide what's best for themselves. So there's no reigning larger decision that everyone adheres to. So there was no organization really in that way. So when they wrote the Constitution, the framers made a federal court system. That means they made a system that the whole country has to follow, every state. Not every state decides something individually. So in that system, there is the Supreme Court, and there are inferior courts. So the Supreme Court has major decision power, and the inferior courts decide things that don't need to move up to the Supreme Court. And the inferior courts handle the vast majority of cases. So the U.S., this is important, the U.S. has a dual court system. So there's federal courts and there are state courts. Remember, I just talked a minute ago about how states used to decide legal matters. In their own way, they still do, but they still have to adhere to the larger decisions by the federal court. So big country decisions that everyone has to listen to versus small state problems that the states handle. So before it goes to the whole country. So there are different types of federal courts. Two types of inferior federal courts. There are constitutional courts and there are special courts. Constitutional courts deal with interpreting what the Constitution says about a particular issue. That's called precedent. And then special courts usually deal with the government doing something wrong. So corrupt politicians, for example, get handled in the Supreme Court, in special courts. So there's this idea of jurisdiction. That means what a court is allowed to handle, what their responsibility is. So jurisdiction is the power that courts have to hear a case. There are two types of jurisdictions. Exclusive jurisdiction. So that's the idea that a federal case can only be heard by the federal court, and a state case can only be heard by a state court. And then there's concurrent jurisdiction, in which, so a state makes a decision, or it's a state case, but a federal court can still hear it. And then there's the idea of original versus appellate jurisdiction. So this is the idea of where the case gets heard. So original jurisdiction is where the case was first heard. So a case gets brought up in California, it stays in California, that's the original jurisdiction. Appellate jurisdiction is when they're not satisfied with the way that case went, or it didn't come to a conclusive decision, so they appeal to a higher court, and then the higher court takes it on to consider a new decision. So that's appellate appeal, that idea. So they make sure that the original court followed the right laws. So let's talk about federal judges. So the purpose of a judge is to interpret the law before anything else. Federal judges are nominated by the president and then confirmed by the Senate. So we're talking about Supreme Court justices. Supreme Court justices tend to follow two philosophies: judicial restraint, and judicial activism. Judicial restraint means that judges think that they should make their decisions based on precedent. So, something's written in the Constitution or a big major decision was decided by the Supreme Court 20 years ago, they're going to follow it. They're going to say, that's what was established before and that's what's going to stay. And then there's judicial activism. So the beliefs that judges should make decisions based on interpretation. This is a belief that times have changed. It's not 20 years ago or 100 years ago, so we take what's written in the law and we apply it to what is now here. Federal judges, like I mentioned before, serve for life, so that way they remain impartial. Real quick, so the picture on the right is, as you know, Brett Kavanaugh. So he's the most recent Supreme Court justice nominated and put in place. And that is it for the National Judiciary. Thank you for listening.